Senator Marshall.
All right, thank you, Mr. Chairman. My first question for Mr. O'Brien. I ran a small business and certainly understood how important certainty was to me running that business. But I hadn't spent as much time thinking about the union town I grew up in, where my family members worked for unions and my friends' parents worked for unions as well. How important is, what does the union and the contract do for the certainty of that working family?
Yeah, I'm sorry about today.
Your first rodeo.
Look, a union contract, I'm a fourth-generation Teamster, so I've seen the value of growing up under a union contract. It provides continuity, security, and benefits to families, which takes a lot of the pressure of raising a family, buying a home, planning for the future. It eliminates a lot of that as well. You know, there's this fallacy that a contract or an organized workforce, the intention is to put that small employer or that business out of business. That is not the intention. I negotiate contracts with the largest corporations down to small mom and pops. And the reality of it is, if people want to get to an agreement, a reasonable agreement that both works for the business and their employees, and if employers truly value their employees, they'll respect the employees' wishes to join a union. Now, conversely, if employers do not want a unionized workforce, it's simple. Treat your employees with dignity and respect, pay them the wages and benefits that they deserve, and you'll never see this face.
Thanks so much, Sean. I certainly do, though. I understand. I'm the banker there. I'm ready to make a loan on that young family's first home. And if they're 2 weeks out from that union contract being over with, it's a lot different situation than if they're in year one of that contract, and that's a good loan to make. I think that's some of the certainty I was thinking about as well. Let's talk about joint employer standard. This is something that's real important to us. And I'll stick with Mr. O'Brien on this. We've seen companies abuse the joint employer standards. We've seen it abused. On the other hand, I'm a big supporter of franchises and think that they do a great job, and it's a great opportunity. They've given so many people their American dream of owning their own business, and I think it's great for women, for veterans, for minorities, great opportunities as well. Where's the opportunity to help take care of some of labor's concerns as well as the franchisers' concerns on when it comes to joint employers? Is there any opportunity for common ground here?
Well, I think we've seen the joint employer argument go both ways depending on what administration it is. And I know you have a bill pending regarding franchisees, and I'll be honest with you, I haven't taken a look at it. The one thing I'm encouraged about what you're doing is that you are looking for a road to consensus on what actual joint employer means, and defining what that is. Often, two times, this joint employer rule has been utilized as basically a regulatory ping pong, where there's really no concrete definition of what joint employer is. We have our own arguments in our own arenas when you're talking about Amazon and big corporations like that, but hopefully with some of this legislation you're putting forth and the conversations, I think what's more important than anything is having conversations and having disagreement, but the disagreement and dialogue leads to a solution that everybody can understand. You may not agree with it, but if there is a concrete definition of what it is, let's just follow what it is and enforce it accordingly.
Give us all some certainty. Mr. Kaplan, I wanted to go to you next. What would be a reasonable amount of time, in your experience, for a newly unionized workers to reach a first collective bargaining agreement? Maybe it's a time frame or a range of time. What would be reasonable in your experience?
I think the unfortunate truth is that it doesn't lend itself to that sort of a clear-cut rule. And I think that that's inherent in where the board sort of sat with the certification bar. When the certification bar was put in, when the recognition bar was put in, people thought maybe 1 year was sufficient. I think that in the current environment where the issues that are being addressed by these collective bargaining units have changed significantly, Just recently, there's been suggestions of political issues coming up in collective bargaining, et cetera. In that sort of a backdrop where the issues have become far more complicated, you're in a much different situation than you were when those bars were put in place. So I guess the question isn't, and I guess that what's fall back on the question is are you bargaining in good faith? Not, is there a prescribed amount of time that these things could be met for everyone? Because not every shoe will fit every single individual. And I don't think it's always clear that 30% means that it was a breakdown.